Welcome. I hope first and foremost that everybody can hear me in their preferred language, either Georgian or English. Welcome to our second cycle on business and human rights, organized by the Human Rights Secretariat with the support of the ILO, and in particular the ILO Danida project on inclusive labor markets in Georgia, on this for this webinar series, which will take place for the next 4 weeks. Before we are starting, just some quick webinar etiquettes, digital etiquettes. So first and foremost, make sure your microphone is muted. At least that is when you are not speaking. So also to avoid any background noise. Also, you will see there is the chat box function. I'm assuming you will be familiar with Zoom, but if not, you will find a chat box function. Please use it in case you have any comments or observations, or if you want to share some experiences or information. In case you have questions, please keep it to the point, especially if the questions need to be translated to English. So if your question is directed to one of the English-speaking speakers, please keep it then short and to the point. Also, for your information, this class is being recorded and will be made available on the eCampus many times the following day. And all the presentations and materials that are being referenced will be made available also together with the recording of this webinar. Now, what do we have? What is on the program for today? As you can see, it will be close to 2-hour webinar, a little bit less. A little bit less than 2 hours. We're now still in the welcoming and in the opening remarks, and I will explain more on what will be this webinar series. Before we then hand over to the main speakers of today, who will provide first an introduction to the ILO, the International Labour Organization, international labor standards and resources. And then we hand over to our Georgian colleague. So every webinar will have more or less the same structure. We always will have a more generalistic approach on the topic. What do international labor standards and conventions say? The second part of every webinar in the future will be with the Georgian perspective and the Georgian approach, the Georgian implementation of those conventions. So we always have these two different approaches in each webinar, also today. And then after 1 hour and 45 minutes, we go into the closing of this webinar. So let's start with the welcoming remarks. And first and foremost, I would like to hand the mic or hand the screen virtually to the head of the Human Rights Secretariat, which is Ms. Maka Peradze. Ms. Maka Peradze, please welcome. And okay, I see you also have your camera on. The floor is yours, Maka.
დიდი მადლობა. მოგესალმებით ყველას. კიდევ ერთხელ წარმოგიდგენთ ჩემს თავს. მე გახლავართ მაკა ფერაძე, წარმოვადგენთ მთავრობის ადმინისტრაციის ადამიანის უფლებათა დაცვის სამდივნოს. პირველ რიგში ძალიან მოხარული ვარ, რომ აქვს შესაძლებლობა თუნდაც ვირტუალურად მივიღო მონაწილეობა ამ ღონისძიებაში და მოგმართოთ აუდიტორიას. გაგამოცეთ ჩემი სიმპათიები აუდიტორიის მისამართით. შესაძლოა თქვენ უკვე იცით, რომ მთავრობის ადმინისტრაციაში ამჟამად მიმდინარეობს მუშაობა ადამიანის უფლებათა დაცვის სტრატეგიაზე, რომელიც არის რიგით მეორე ეროვნული სტრატეგია და მომდევნო 10 წლის მანძილზე განამტკიცებს ადამიანის უფლებათა დაცვის სტანდარტებს, რომლის
now we will elaborate also execution mechanism for implementation of these standards, which will be part and parcel of the strategy. It will do our utmost to guarantee its implementation. There will be person responsible for its implementation, institutions. Why I refer to human rights strategy? Of course, human rights strategy, first of all, is based on the fundamental human rights, which are enshrined in different international instruments and which is part also of our national legislation. And this document to promote human rights in businesses one of the most important priorities. This direction, I would say, is a quite new one for our society, for the political class. And this is still a challenge, and the very fact that it became a priority, I think, speaks a lot. And we have got quite ambitious plans, and we'll do our utmost to live up to these ambitions. As you know, the Public Service Bureau and with this technical support of ILO within the framework of this project, which is called Inclusive Labor Market in Georgia for the creation of jobs. Well, a number of webinars series were held, and 47 employed persons participated in it. Also, webinar seminar on human rights and business, international labor standards were held, which aimed at capacity building of employees, employers to raise awareness of the whole society of the important link between the human rights and business development and promotion in our country, and which mechanism should be applied to guarantee proper introduction of the highest standards of human rights. Well, series of webinars which were held in May and June, well, will be held, sorry, and it will cover issues like international labor standards, child labor, forced labor, OSH related issues, also equal opportunities for workers, also different grievance mechanisms to be applied, social protection, a number of other important issues, and so on and so forth. Well, Human Rights Secretariat of the government of Georgia, well, we together with our partners in the second part of this webinar series, well, invite 50 more public servants who will be attending this series of webinars. I do hope that this, am I speaking too fast? Maybe. Well, just we elaborated number of activities and a number of cases. Due to some existing crisis, we face a number of challenges, and we will modify our modus operandi. And I do hope that we, within the framework of this project, will be able to carry out all set activities. I would like to thank you for showing keen interest in this issue, and I would like to wish you, first of all, good health, very successful and result-oriented activities. Thank you very much for your kind attention.
Thank you, Maka. And I would like to hand over now to Mr. Katalin Hakura, who is the Chief Technical Advisor of the ILO Danida project of inclusive labor markets for job creation in Georgia. Katalin, please go ahead.
Thank you, Carl. I think my audio is okay. Yes, okay.
We can hear you.
So my name is Katalin Tsaku. I'm managing the ILO project, Inclusive Labor Market for Job Creation in Georgia. It's an ILO project, but it's important to mention also that this project, it is financed by Danish government. And this year, it's almost the fourth year when ILO deliver its work through this project in Georgia. One of the elements of our project framework, it is dedicated to business and human rights. Together with our constituents in Georgia, on one side, the government represented here by Human Rights Secretariat, but also through our social partners constituents, which is the Georgian Employers Association. And regarding the course today, we are pleased that we can arrive to this course. This is the second series of this kind of courses with excellent cooperation with the International Training Center of International Labour Organization. And about the content of the course, Carl will explain in details. What is important, because the legal framework on national level, sometimes it faces a lot of changes and a lot of developments. Sometimes maybe the international legal framework, it's not completely applicable, applied, or developed on the national level. And this is the reason why the international labor standards that International Labour Organization provide and support and promote within all the nations are very important. They are practically the reference point and the reference support for your job. And this is the reason that we are very happy that we can deliver this training session to you. And I'm sure that all the high-level specialists that will participate in this training will be able to deliver you the best content possible in order to use it in your normal activities in Georgia. Thank you.
Thank you, Katalin, for these opening remarks, and also thank you, Maka, for your opening words. Well, let's go into the objectives of this course, which will take 16 hours of your time, 16 hours spread over 4 weeks. We will see in the next slide how that will look like. But what are the objectives? Of course, the idea is to provide you a first general introduction to be knowledgeable about the whole discussion on business and human rights, specifically as it relates to Georgia, because Georgia has established already a national action plan on business and human rights, which is detailing the aspirations of government and the activities to advance this agenda on business and human rights. But of course, business and human rights, it's a whole big universe. We want to focus in these next 4 weeks on the issue of international labor standards, as already was mentioned also by Catalina. We really want to specifically focus on labor rights related human rights and responsible business practices, always looking for that these connections between labor standards and the business and private sector activities. That's what we will be doing for the next 4 weeks. You will have 2 webinars a week for the coming 4 weeks. Today is to provide you with a general introduction on what are international labor standards and how are they being applied here in Georgia. Next week, the next session on Thursday will be on occupational safety and health. Again, here focusing on the general principles. The second part is what is now the current legislation and the current practices in Georgia concerning occupational safety and health. The following webinars which we will have will be looking into the issue of forced labor, grievance mechanisms, child labor, equal opportunity and treatment of workers, the women economic empowerment principles and sexual harassment. And the final webinar will be on freedom of association and collective bargaining. How will we be organizing this? Of course, sometimes it can happen that you cannot be part of a webinar. Please you will be enrolled, or I think you already have been enrolled to the eCampus. So in case you could not attend a webinar, you will always find the recording of the webinar on the IDC ILO eCampus, which is the online learning environment where you will find all the information about the webinars and all the references that were made in those webinars. You will find it here in English and in Georgian. And normally everybody has already access to it. If this is not the case, please let us know. Just send us a message, even in Georgian, in case you cannot access the eCampus. Now, another important element is you will receive a certificate of participation. We already want to make clear we will not be policing participation, but we will be monitoring it. And of course, there will be moments that you cannot attend the webinar because of other obligations. That is fine. That is not a problem. This can happen once in a while. Of course, if this is happening throughout the webinar series, you will not receive the certificate. We really look for participants that are consistently participating into the webinar series. So we will not count this first webinar because maybe there were still some technical issues why not everybody could participate, but from next week onwards, we will monitor a bit more the participation. Okay, let me then hand over to our colleague Leo Siebel from the ILO office in Moscow, where he's a specialist on international labor standards for the first session on an introduction to international labor standards. Leo, please, the floor is yours.
Thank you very much, Carl, and good afternoon, ladies and gentlemen. It's a pleasure to be able to join you. I would prefer to do that in person in Georgia, so that afterwards we could perhaps hang out and have some khinkali and some wonderful Georgian wine, but unfortunately that's not possible. So I'm afraid you will have to bear with me as I take you through some of the basics concerning the ILO, what it is, what it's supposed to do, and the role of international labor standards in what we do, and also how they are of importance to you. So first of all, a little bit about the ILO. We are an old UN organization. We were established in 1919 as part of the Treaty of Versailles, the peace treaty that ended World War I, and we predate the UN. We were established at the same time as the UN's predecessor, the League of Nations. Now, more importantly, are some of the reasons why the ILO was established. First, here you see three of them. I'll dwell a little bit on two of them. First of all, there were the effects of industrialization. For the first time in history, we saw the creation of a large pool of workers working in newly established industrial enterprises, in textiles, in metal factories. And in the absence of any form of protection, their working conditions were often abysmal. There was widespread child labor. There was no protection of pregnant women, for instance. Contracts were largely unheard of. If you got sick or had an accident too bad, you were sent home, and the boss in most cases would just hire somebody else. And it was felt that this growing group of workers who not only worked together, but often also lived together in abysmal circumstances needed support. There was the humanitarian sense that this could not continue. And that was one of the reasons for the establishment of the ILO. I don't have to dwell upon the effects of the Russian Revolution, as you are more than acquainted with it. But perhaps, since we are talking here about human rights and business, responsible business behavior, the third one, the economic aspect, is most relevant for our discussion. So one of the reasons for the establishment for the ILO is to make sure that there is competitive level playing field between countries, so that countries that respect worker rights do not suffer negatively in their competitive position from having to compete with countries that do not provide basic protection of workers. The understanding is, to some extent, that the protection of workers in terms of making sure that they're safe, occupational safety and health, that they have the right to freedom of association, that there's no forced labor, no child labor, that to some extent there's a cost involved and it would be unfair if countries could undercut other countries simply because they do not protect worker rights. And the same goes for businesses. And that is part of the reason why increasingly we see businesses supporting regulatory frameworks, because they feel, why, if I want to behave responsibly, would I have to compete with a business that is exploiting workers? So this level playing field argument also works at the national level. And of course, because of current globalization, this process that we are all familiar with, this is emphasized because more and more you have large companies that are based in one country, but that buy their products in another country and then sell it in a third country. So this level playing field is important, not just between countries, but also between businesses. And this is one of the reasons why the ILO was established. If there's one thing that you should remember about the ILO, is the fact that it's a tripartite organization. Unlike other UN agencies, such as UNICEF, that deals with children, as I'm sure you are aware. Of course, everybody now, because of the pandemic, knows the World Health Organization. These UN agencies only have states as their members, whereas the ILO is tripartite, meaning that there's not just governments, but also employers and workers who are members. And this is reflected in all important decision-making processes in the ILO. Our program budget is adopted by these three parties. Our boss, who is called the Director General, is elected by these three parties. And labor standards, what we will focus on today, are developed by these three parties. So how do we work in practice? In essence, the ILO is a standard-setting organization. We develop international labor standards, and everything else we do is aimed at ensuring that those standards become a reality, not just in law, but also in practice at the national level. So the project that cooperates with the Human Rights Secretariat in Georgia has different activities, and all of these activities are guided by the international labor standards of the ILO. They're aimed at ensuring, including what we are doing today, the first webinar in this series is aimed at ensuring that these standards become a reality in this case, in Georgian law, but also in Georgian practice. So when we talk about these international labor standards, what are we talking about? Predominantly, we are talking about two types of standards, as we call them. There are conventions and there are recommendations. The conventions are like international treaties. They are legally binding when they are ratified by a country, meaning that when Georgia ratifies a convention, that means it has an obligation under international law to make sure that its national legislation and practice are in line with the requirements of this particular convention. There are 190 conventions. In addition, there are ILO recommendations. There are 206 of those. Those are not legally binding. They cannot be ratified, and they provide general or technical guidelines with regard to a certain subject that they cover. Often what we see is that there is a convention on a certain subject which provides broad general principles of law. And then on the same subject, there is a recommendation that provides much more detailed guidance on how these broad principles of law that are contained in a convention can be implemented in practice. So you have a convention and a recommendation on the same subject. But a simple look at the numbers, there are 190 conventions and 206 recommendations, will also tell you that there are recommendations that are standalone. They are not linked to a convention, but the tripartite partners, the constituents, so the government, the employers, and the workers, decided that this subject could not be, did not lend itself to regulation through a convention, but rather the preferred option was to use a recommendation. Now, there are 190 conventions, and the ILO has classified these conventions. And throughout this webinar series, we will focus on a number of the conventions, and especially some conventions, some categories of conventions. So there are 8 so-called fundamental conventions. They deal with human rights issues, forced labor, child labor, freedom of association, and non-discrimination and equality. And all of these 4 subjects are covered by a separate webinar, partly because they are so important. There are 4 governance conventions. They deal with employment, labor inspection, and something that we call social dialogue, which is the way in which the government interacts with employers and workers at the national level. They are called governance conventions because they deal with the way in which a government manages its labor market, how it sets up the labor market and how it manages the labor market. And then there are 177 technical conventions, and these cover a whole range of different subjects. Occupational safety and health will be covered next week, on Thursday. Other standards may cover social security, but there are also standards that deal with particular groups of workers: seafarers, migrant workers, domestic workers. So there's a wide variety of subject matters and groups of workers covered by these 190 conventions. So let's take a closer look at these fundamental conventions. Already mentioned: freedom of association, freedom from forced labor, freedom from discrimination, and freedom from child labor. And each of these categories is covered by 2 conventions, and you will learn more about these throughout the course of this series of webinars. But why are they so important? Why are they considered to be fundamental? They are because we consider them enabling rights, which means that if workers do not have the right to form a union, in other words, if they do not have the full right to freedom of association, it's going to be very difficult for them to ensure that their other rights are protected in case of violation, in case there's a problem with occupational safety and health, or when their wages are not paid. If one worker has to go to the employer, their situation is much weaker than if a trade union, i.e. a group of workers, can go to talk to the employer. The same with child labor. If you have child labor, if you are subjected to child labor, that means that it's going to be very difficult for you as a child to go to school, to finish your school, to fully develop your intellectual and emotional capacities, grow into a well-rounded human being, and are going to be in a position to choose the work that hopefully you are best at and that you enjoy doing. This is not just in the interest of the individual concerned, but also in the interest of society, because every time a child is unable to go to school because he or she is subjected to child labor, means that his or her potential is lost also to society. Another reason why they are considered fundamental is because they have received unanimous and universal acceptance. Often what you see is that other human rights instruments, such as UN, United Nations human rights instruments, also cover these subjects, and sometimes they even borrow definitions and language from ILO conventions. And it should be understood, and this is universally applied, that it doesn't matter what level of social economic development the country is at, they must respect these fundamental human rights conventions. Perhaps a step towards your next webinar, but there's, I'm sure they will mention it on Thursday, but there is a debate globally ongoing, but specifically within the ILO, to designate some occupational safety and health standards also as fundamental human rights conventions, in recognition of the fact that lack of respect for occupational safety and health has a profound effect on people, on workers' lives, sometimes even death. And this right to life needs to be protected and recognized as a fundamental human rights issue as well in the world of work. Now, 190 conventions. Georgia, with all due respect to Lika, the next speaker from the Ministry of Labor, is not a very high rate of ratification. But the most important thing is not necessarily the act of ratification. You can ratify 80, 90 conventions, but if you then don't do anything to implement these conventions, then there's no point. It is better to make a considered assessment on what the pros and cons are of ratifications, in how far it affects your legal framework, in how far it affects your practical, your administrative system, and then decide, I want to ratify this convention because it will help me address a particular issue. And here I'm happy to say that over the past few years, Georgia has taken a much more structural approach to ratifications. It ratified one convention on social dialogue, tripartite consultation. So again, discussions between employers, government, and workers. The ILO and other UN agencies have helped the government develop RIA's, regulatory impact assessments, to see in how far ratification of a convention, whether it's on maternity protection or domestic workers, or in the future on forced labor instruments, fits within the policy priorities of the government. And here you can also see which type of conventions have been ratified. And here it must be noted that Georgia has ratified all 8 fundamental human rights conventions. So what happens when a government ratifies the convention? Once ratified, again, there's an obligation to ensure that they become a reality in law and in practice, meaning the law needs to be changed if necessary, and administrative or practical aspects of the implementation of the convention must be reviewed and adjusted if necessary. And to assist in this process, the ILO has established a supervisory system. Now, there are different aspects to this system, but today we're going to focus on what we call the main supervisory system, which consists out of 2 pillars, 2 processes. The first is the Committee of Experts on the Application of Conventions and Recommendations. We, in the ILO, we call this the Committee of Experts. This committee is composed out of 20 independent and impartial experts. They do not report, or they should not report, to any governments, nor any employers or trade unions in the country or region from which they come. They are truly global representatives. They include academics, judges, and other experts. Now, what they do is they look at reports that each government who has ratified a convention needs to submit to the Committee of Experts. And this report looks at to what extent and how a government has ensured that its law and practice are in line with the requirements of a ratified convention. So these experts undertake a technical examination of this report, but they also look at other information. Because we are a tripartite organization, employers and workers also have the right to submit information to this committee. The Committee of Experts also looks at other, the comments and observations of other UN agencies, and to some extent, information from non-governmental organizations. Now, based on this technical examination, the committee of experts may say, all right, the convention requires this, but your law says something else. Please change your law. The convention may say this, but in practice, you do not meet this standard, so please change your practice. It does that by issuing comments. So what we have is a paper exchange of information. It's a paper dialogue. And the objective of this system is not necessarily to punish anybody, to name and shame anybody, but rather to create a dialogue which is beneficial for governments so that they are able to adjust their laws and practices where needed. And if you look at the comments issued by this committee of experts, you will see that all countries from across the globe are covered. There are comments on Georgia, but there are also comments for my country. I'm from the Netherlands, Russia, the US, the UK. All countries are covered. And normally what we see is that this system leads to improvements. Laws are improved, practices are improved. But sometimes more is needed. In cases where there are severe shortcomings in law or in practice, violations of the requirements of the conventions, countries can be called before the second pillar in this system, and this is the Committee on the Application of Standards of the International Labour Conference. So the International Labour Conference is the ILO's General Assembly. It's where all the members, so governments, employers, and workers, come together on a yearly basis, and they are about to meet, well, they've already started meeting for this year's conference. And one of the committees on this conference is the CAS, as we call it, the Committee on the Application of Standards. This is not a technical body composed of experts, but rather it's a tripartite body. So it's composed of governments, employees, and workers. And here, the CAS invites governments to appear before it in person, or this year because of COVID, virtually, and explain to the CAS why it is not implementing, why it is not ensuring conformity of its laws and practices with the requirements of the convention. So every year there are about 24 countries that are asked to appear before the CAS. And again, we see virtually all countries from the globe at one point or another having to appear before this committee. Again, my country in recent years has had to appear before this committee for labor inspection issues. Georgia has had to appear because of gender equality issues. But again, this is only for those countries where there are serious or long-term challenges in ensuring the application of a convention. Now, what does this mean in practice for you, for the participants in our webinar series? Over the past 2 years, the ILO has worked with our partners, with the government, the employees and workers, but also with the parliament in revising the labor code. We've worked particularly intensively with the parliament, and as a result, in September last year, your labor code was amended. And many of the amendments are based on these ILO conventions. The ILO assisted in this process. I had the privilege of being involved myself. So we helped draft some of the provisions of the amendments. At the same time, a new law was adopted, a law on inspection services. And as a result, an inspection service, a legal entity under public law, was established in Georgia. And here too, the ILO assisted. So this law is drafted based on these ILO conventions, in this case, ILO Convention 81 on labor inspection. So the legal framework of Georgia was adjusted in line largely with these conventions, especially the law on inspection services is one of the most comprehensive laws that currently exist in the sub-region when it comes to inspection, the establishment of inspection services. So Georgia can be proud of this law. Another example that I can give you is that, again, over the past few years, because until fairly recently, there was no inspection service, workers and employers, whenever they had a dispute, they had only one place to go, and that is to the courts. So we worked with the High School of Justice, but also with the Supreme Court in training judges and later on also lawyers on what these conventions mean, what their contents is, and how they can be used by judges and lawyers to resolve disputes at national level. And we've tracked the statistics, and we can see that over the past 5 years, increasingly, judgments, court judgments in Georgia are based on or take into account some of the requirements, some of the provisions of these ILO conventions. So for both business and workers, national legislation, but also the judicial application thereof through your court system, increasingly over the past few years has been shaped by these international labor standards, which means that if businesses follow the law and follow court precedent, then their behavior will most likely be more or less in line with international labor standards and international human rights standards. So that's at the national framework. But also, I've been fortunate enough to visit Georgia frequently before the pandemic. So I know a little bit about where the best shops are and where people go for when they want to hang out in the mall. And I myself have also bought certain things in Georgia. And when I do that, I'm aware that there are differences in the way clothes, for instance, are made. If I go, and I'm sure that some of you do this as well, if you buy clothes in H&M and Zara, then even though H&M is a Swedish company and Zara's business headquarters is in Spain, these clothes are not made in Sweden and Spain. They are made mostly in Asia. Why? Because the costs are lower. And then the question becomes, in how far are working conditions respected in those countries? And in that respect, many businesses, many international businesses, but increasingly also national businesses, they develop codes of conduct, standards based often on the ILO conventions and other human rights, on which they base their conduct. So if H&M places an order in, let's say, Bangladesh, then the factory that produces the clothes for Bangladesh has to ensure that they meet the requirements of this code of conduct. And since the code of conduct is based on international standards, that means this factory has to abide by these international standards. So that means that the clothes that we buy, depending a little bit on which company you buy them from, also contribute to respect for worker rights in faraway countries, not just in Georgia and not just in the rest of Europe, but also much further away. So there are many different linkages between this system and the way businesses operate, and also how we, regardless of whether we are in the Netherlands or in Georgia, how we interact with each other and how businesses should interact with workers. And hopefully throughout this webinar series, you'll learn more about this. Thank you very much for spending some time with me on this. You will hear next, but I'm sure Carl will make the introduction, from the government on how we interact with each other and how they position themselves within this system of ratification and reporting. Thank you.
Thank you, Leo, for this presentation. A very clear and very informative breakdown of what might look to be a very complex system, the system of international labor standards, but also how it touches upon all of us, the responsibility in terms of international labor standards. Are there any questions that you would still like to ask Leo? Then we can now have a few minutes in that regard. So if you have a question, you can even take the floor. I would say you can take the microphone, or you can put it in your question in the chat box. I'll give you a few seconds in case you have a question or a follow-up question. And I suppose that is Taco writing in Georgian if you have a question. If not, think about if you can still ask your question also after the next presentation. So nobody, one more time. Good. Okay, then I'll propose that we thank Leo for his presentation, and we now continue with Lika Klimiashvili. I hope I pronounced that correctly. Well, the microphone is yours. Please go ahead, Lika.
Thank you very much. Welcome, everybody. I'm really honored to be part of this webinar seminar. My name is Lika Klimiashvili, and I represent Employment and Collective Bargaining Department of the Ministry of Labor. Well, just labor and health. But I will speak now mostly about the labor dimension of this ministry. I thought what I'm going to talk about while talking about international labor standards in Georgia, and I decided to address a number of very important issues, which are part of Georgian commitment, before the international community, also directions and priorities which have elaborated in our cooperation with the ILO and with the lavish support. Before getting down to specific issues, let me offer you introduction. I'm very glad that this field is developing, and we're engaging more and more people to become part of this paradigm. We talk a lot more about standards, about labor rights, about human rights, and what needs to be done to make sure that these rights are protected to the best possible extent. Well, for the last decades, nothing similar would happen in Georgia. We do not have a legislative base and no institutional arrangement which would promote human and labor rights. And since 2006 up until 2012, all this space was empty, and just only interests of employers were taken into account, and labor rights were ignored. I would say completely ignored, and every single disputes were decided, in favor of employer. Unfortunately enough, of course, this reality posed a very serious problem to their whole country, and first and foremost to the employees, and we're still yielding very negative results of such an approach. Well, we lost a culture of OSH, we lost a lot of culture in this field, and the labor department were just set up not long time ago, and people just were not aware about the basic labor rights. So after new people came to the government, the new government decided to make this issue a priority, and we came to appreciate that proper regulation was to be introduced. We signed a number of new documents, and now we are committed to this cause. As Leo mentioned, for ILO is in existence for more than 100 years. It adopted 190 conventions. So, well, we're lagging behind a lot when it comes to the number of conventions ratified. But still, the progress is visible for recent years, and the progress is also very tangible. So, uh, Georgia became ILO member state back in 1993, and beginning from 1990s, now we ratified a number of conventions, but in reality, they were not implemented. They were conventions only on the paper, and almost nothing was done to harmonize our practice with the best international standards. The last convention which we ratified was back in 2017, convention number 144. So, and it was about tripartite, just nature of convention and dialogue, the importance of social dialogue. And I personally participate in the procedures of ratification of this convention, and I'm very proud of being part of this process. So, so I will not refer to all conventions which have been ratified by Georgia, but let me underline other conventions like, the prohibition of forced labor, freedom of association, collective bargaining, equality of men and women, equal remuneration for a male and female. So, like, just some conventions are technical, but still, also private agency of employment, the worst methods of child labor, and also other conventions. What have been done is not indeed good enough, and I'm fully aware of this fact. A lot more needs to be done. I think in this stage, well, we have to pay more attention to Convention 181 and also the protocol, on forced labor. Also, with the support of ILO, we are trying to introduce some regulatory norms. And together with our social partners, I do hope that just we'll be able to ratify these conventions sooner rather than later, as it was mentioned by Leo. The law which was adopted on labor inspection is really one of the best and is very close, just in line with the best international practice. So when we're talking about ILO international standards, one issue is, well, the one institution is the Ministry of Labor, which talks on behalf of the government of Georgia when it comes to elaboration and implementation of convention. We would every year in September will send to ILO our report and listening very carefully, to the comments and recommendations on the part of ILO Committee of Experts. So we took all these recommendations and observations very, very seriously. I would like to assure you. And and we use these recommendations as a point of departure for our policy. As I mentioned, I will address a number of issues, and I think these are the issues which are important for all parties engaged, for employers, for employees. First of all, let me talk about labor relations and labor legislation, labor code of Georgia. As I mentioned, we started very serious working uh, in 2013, and the first serious wave of changes took place in 2013 when amendments were introduced to the labor code of Georgia, and we brought it very close or closer to the international standards. We introduced and set up tripartite commission, and now labor code is quite good and workable document. And attachment of 21, just by the of the Georgian EU Association Agreement also is very important document and is a very strong motivation for Georgia to do its utmost to bring its norms and standards closer to the best international ones. The second stage was amendments in 2019 relating to issue of non-discrimination in the labor market and the working place, and to guarantee the principles of equality. Also, we address the issue of sexual harassment on the working place, and also the law on non-discrimination have been of Georgia have been amended. So, and very important amendments have taken place in September of 2020, and it was a very important step. So, and I would say that situation has improved substantially due to these activities, due to these amendments to the law and new laws adopted. And now we have very good implementation instruments. So I've got a list. What issues have been addressed in the labor code and what commitments have been taken by the employers. So almost all these amendments are very, just intertwined. So we pay special attention to fight against all forms of discrimination, both direct and indirect discrimination, and also, to bring them closer to ILO standards. It is referred to in this document of the importance to guarantee equal payment, equal remuneration for equal value work. And it is an obligation of employers. Also, on the labor discrimination disputes. So if in case person has been dismissed, the burden of proof is now on the employer. Amendments also addressing issue of labor contracts, also the time and deadlines for labor contracts. So also the obligation of employer to notify employee about possible dismissal and many other related issues. So also a number of norms, new norms have been introduced to this legislation. So also, we have the reference to the full-time and part-time job and the remuneration. Now a very clear definition of what is meant by part-time and full-time job, and also, the prohibition of different approaches when it comes to full-time workers and part-time workers. Also, some additional privileges for pregnant women and breastfeeding women have been introduced. Also, the obligation of employer to guarantee professional qualification and also prenatal, just medical examination, for pregnant women and some additional days to the waiting. So, and this is very important change. These are rather very important changes. So, and we are doing our utmost also to improve Georgian practice when it comes to working hours, also paying for overtime to be in line with the best international standards, and also when it comes to working hours of people underage. Employers are obliged, I think you are fully aware of this, that, to pay special attention to the personal development of people underage. A special decree of Ministry of Labor and Health has been issued to this regard, and this issue is very important now and high on agenda, as well as the labor inspection services. Also, night shift, day shift, payment for a night shift work. So, yeah. Also, well, and now in many respects, our law is more, adequate. Also, when it comes to maternity leave, it is now more detailed, and now fathers also are entitled to use uh, paternity leave, I would call it. So this is a quite new notion, and we're doing our best to promote this new practice. So also right to go on strike, also flexibility of massive, dismissal. And now more attention I would like to assure you is paid to the rights of labor when it comes to right to go on strike. So now we've got the whole list issues which have been addressed, in the course of last years, and of course, what we are going to do in the nearest future. And the most important issue, to the best of my judgment, when it comes to these changes in the law and in the practice, so the labor code. So, and for the implementation of all these amendments, who are responsible? Labor inspection. So the establishment of new labor inspection is a very important step forward. And the labor inspection is a very institution which should guarantee, these amendments, which should guarantee that individual labor relations, are in full line with the requirements of international labor organization, its conventions and recommendations. So when it comes to labor relations, it's not only about the labor relations as such on the working place, but it has far wider connotations. If we will move now, let's move to the labor inspection issues, which is the most important issue, I would say, right now. And now, so it took years and years, and a lot of human investments have been invested in order to establish proper and adequate labor inspection service. And many important steps have been taken in this respect. So let me explain how it all started. So 10 years ago, we did not have labor inspection as such. So, and many would say, establishment of a labor inspection would be a serious blow to business. Well, of course, it proved to be wrong. And in Ministry of Labor, first of all, we set up a department which was entitled to elaborate new institution. Initially, it had a mandate only to provide recommendation, no more. Now, it was very limited in its power. So, but for this, sorry, and it was a decision of social partners, you know, to set up new institution, which was crucially important for labor relations in Georgia. So, yeah.
შრომის ინსპექციის კანონმა კოდექსის ცვლილებების გაგრძელებასთან
So maybe you will ask her to speak a little bit slower. She's speaking with abnormal speed.
კანონმდებლობის შესრულებას და კანონმდებლობა მოიცავს ამ განიმარტა როგორც შრომითი ნორმები კანონით. შრომითი ნორმები
So
მოიცავს
labor norms, just covers a number of important issues. And, well, a number of amendments have been introduced to a couple of Georgian laws, which were brought in line with the requirements of the time. And now labor inspection has very wide mandate, which would allow him to face the challenges, which this law, the came into force from January 2021, and now we're at the stage of institutional development. Altogether, there are around 60 inspectors in Georgian labor inspection, and hopefully by the end of year, the number of inspection will be increased by 40. We'll have by the end of year at least 100 inspectors will have our offices in Ajara and Imereti region. And so, and the pandemic showed us how important it is to have in the country strong and effective labor inspection. Once again, now there are no doubts whatsoever in any headquarters that labor inspection needs to be furthermore strengthened, and it should be furthermore prioritized and respected by all parties, involved. So only by doing so will be able to protect best legitimate interests of workers, and not only workers. So let me talk about Next standards, when it comes to freedom of association and collective bargaining. As I mentioned, we have got ratified all fundamental ratifications. And let me, single out Convention 87, freedom of association, and Convention 98 about collective bargaining. So freedom of association means that both employers and employees should have freedom to set up the association, be members of this association, and to talk about within the framework of collective bargaining with employers, employees. So to have common voice, how to protect their best and legitimate interests. This Convention 98 also would indicate that any employee should be free from discrimination, you know, and every single worker should be free to become member of trade union or any other association, and nobody is entitled to intervene in the work of this trade union, and otherwise it would be considered as a manifestation or practice of discrimination, which is prohibited by Georgian legislation. So when it comes to collective bargaining, as I mentioned, they are also very, very important. So it's crucially important for all parties to be able to work together, to protect their interests. Unfortunately, culture of labor relations and collective bargaining is not good enough in Georgia. There is a lot of room for improvement. But I do hope that the new dynamics would allow us to introduce this culture, to cherish it. And just 1 month ago, Georgian manganese company, there were a collective dispute, and the parties came to a common denominator thanks to collective bargaining. That's a very good example, which should be followed and which should be emulated in the future by other parties as well. So there is a possibility, and there is always chance to gap the differences through the collective bargaining. So let's wrap up.
ხო. როდესაც კოლექტიურ, ასე ვთქვათ, მოლაპარაკებებზე
When we're talking about collective bargaining, we're proud to mention that since 2013, after amendments have been introduced to the labor code, then we introduced the mediation system. This is an opportunity which would give chance to employers and employees, to fill the gap in their positions within a very short period of time, to sit around the table, round table, and to solve the disputes in a peaceful manner. So the respective article was introduced in the labor code, and the government issued a decree which would define procedure for mediation, procedure number 301. And so this institution also proved to be successful and result-oriented. So, so there is a department which deals with the collective bargaining and collective disputes I'm in charge of. So what we're doing in this respect? So we meet on a regular basis with the employers and employers. So employees, at least 20 persons are authorized to write a letter to the Ministry of Healthcare and Labor and to demand to say to single out a mediator for the disputes. We've got a roster for mediators, which is approved by the Ministry of Labor and Healthcare, and which is also approved by all three parties, government, employers, and employees. We agreed. And we have now new rooster, which has been approved in July 2020. Altogether, we have 17 such independent, highly qualified mediators in this list. who would address such disputes and would help employers and employees to solve their problems. Also, law would define that. Ministry of Healthcare, in case of high public interest, upon his or her initiative, would, single out mediator for the cases. So we use such an opportunity only once. In other cases, initiative would come from workers in the vast majority of cases, and sometimes, from employers as well. So let me repeat myself. Mostly employees are initiators of these dispute dispute solutions remediation service. What are the issues mostly of this dispute? So, so according to statistical data we have got at our disposal, it's the first issue is remuneration. Second one is, contract signing, contracts themselves, and also issues relating to membership of workers, trade union. Also, the third issue is OSH and related items. And I would like to tell you that in recent years there were disputes when parties would ask us to single out mediators, and they would say that, decisions made by mediation have not been implemented. That's why they call for new mediation procedures. So now I think the creation of stronger labor inspection would help and would promote success of mediation process in the future as well. There is a very direct linkage between the two. One, when it comes to vacancies and also issues relating to workers who work in the very hazardous conditions, additional payment for them. So when it comes to success of mediation, it's very difficult to predict. There are many elements and many composite parts, and there are many factors which should be taken into account. Well, sometimes they're successful, sometimes they fail. So, but in the vast majority of cases, at least in Georgia, mediation services proved to be successful one, and I think we need to do a lot more to improve the quality of mediation in Georgia. Well, well, there are many factors of failure. First of all, I would call the lack of trust between the parties, and there are no clear-cut rules of game agreed upon between the parties. And also, sometimes people who are around the table are not decision makers, who are not influential. So mediation is a mechanism which quite often is used when it comes to strikes. So, so before going to strike, they have to feel, just some procedures, so-called 21-day, just period. Only after that they can resort to strike. We know quite well about the problems which do exist in our system, and we're at the stage where together with our partners, with the participation of mediators, we are working to improve the existing system. And of course, ILO here is instrumental. And we highly appreciate the technical support. And we together work to improve the standards of mediation and collective bargaining, and to respond without any undue delay challenges we face in this respect. So, well, because mediation is the best option to avoid going to the court. So, because court is very time consuming, effort effort consuming, and it's very costly financial wise. And that's why we think that we're ready to work further to introduce new amendments and to take more concrete and result-oriented steps to improve the system as a whole. So when you talk about International Labor Organization, about labor, the point of departure for us, the major principle we based on is a social dialogue between the parties. So before, the ratified convention 144, just as I mentioned, in 2013, many serious amendments have been introduced into the Georgian Labor Code. We set up tripartite social partner commission, which played also a very important role to address and to solve the problems which did exist. So, and we carry out quite serious reforms in this field. And all these issues should be continued to be addressed by all three parties. So, government, employers, and employees together, especially when it comes to employers and employees, should work together. And the government also should do its utmost to strike a balance and to do its utmost to increase the level of trust between the parties. We're not the government here, to side with one party or another. No. So, so, uh, but point of departure that to improve the working conditions of all workers, women, men, and it could be achieved only through social dialogue, which should be carried out in good faith. And tripartite commission between the parties was set up in October 2013. And every single party has in this commission 6 members. And Prime Minister of Georgia is head of this commission. So, so if Prime Minister is not able to attend the meeting, Ministry of Healthcare and Labor, usually would be in charge of this tripartite commission. On the part of the state, just who are the representative in this commission? Ministry of Justice, Ministry of Economy, Ministry of Education, Ministry of Healthcare and Labor, and Ministry of Regional Development and Infrastructure. When it comes to employers and employees, well, our major social partners are, you know, which is recognized by ILO as a partner, also Employers Association of Georgian Trade Union Confederation, GTUC, and they have, 5 professional organizations represented in this commission. So, and the commission is, had the mandate for 1 year, but used to have. Now it has a mandate for 3 years. A tripartite commission would convene, just at least once in a year and will elaborate a working plan and would set up standards, and directions, major directions and priorities of the government in this field. And so, and every year, through the working group, based on the fact that commission is composed of high-rank officials, so we, set up a working group which would prepare materials, and would prepare meetings. And in this working group, you will find members from trade union, from employers association, governmental officials. So, of course, well, unfortunately, just these meetings are not regular. I think we have got to guarantee more frequent meeting of these group and working groups. But working groups are communicating on a regular basis. I would like to assure you, and all major issues have been addressed within the framework of working groups. Well, it is our expectation to improve the quality of work of this commission and to make it more regular and make sure that the decisions are implemented to the full possible extent. And once again, I think that we'll be able to do so thanks to support of ILO, the technical support, and we highly appreciate the support when it comes to improving the capacity of the Human Rights Secretariat, also the Secretariat of the Tripartite Commission. So, once again, a lot more needs to be done in this respect to make this commission more effective and more result oriented. Well, I think coming to the near. So after the amendments have been introduced to the code, well, some transitional articles, just are now being elaborated. And also we're thinking about some amendments to be introduced in some other laws. And we work together with our social partners, together with ILO experts, and also we have the list of specific type of work, about the need to have more regular medical checkup for workers who work in the hazardous conditions. So maybe I'm repeating myself, but let me underline that an important steps have been taken forward. That nobody can deny this fact. So, yeah, the protection mass and legitimate interest of labor rights is a priority of the government, current government. So, and now, ministry is more open to listen carefully to the needs of workers as well as to the needs of employers. So, so it is an approach of the state. Of course, what have been done, is quite impressive, but there is no time to relax and to be satisfied. New steps, more brave steps needs to be taken, but it could be possible only through cooperation between all three parties. And a lot more needs to be done when it comes to ratification of ILO convention. And the special attention is to be paid to the violence on the working place, harassment, including sexual harassment on the working place. Thank you very much for your kind attention. And you have got any questions, I am at your disposal.
Thank you.
I've got a question, Madluba.
Yes, thank you, Nika, for this presentation. Very interesting. And of course, it's clear that a lot has been done in the past years in terms of advancing the decent work agenda in Georgia. There was one very interesting question that came in on how the trade agreement, the association agreement with the European Union, if that is one of the reasons maybe, or if that has impacted in a positive way the issue of protecting workers' rights, if this has impacted positively in amending the labor code. And I would like to ask also Leo to give Leo's view on this, and then afterwards also Lika's view on this. And if anybody else in the room who works on this topic has a view on this, please also do share it. But maybe Leo, you would like to opinion on this or comment upon this?
Sure, and that is indeed a very good question. And the answer is yes. Georgia's efforts and westward orientation and ultimately the goal of joining the EU has definitely played a positive role, I would say, in over time raising awareness first and foremost about trying to find a better balance between the rights and interests of workers and employers. Under previous administrations, that focus was clearly on the rights and interests of employers, and Georgia, to some extent, is rightly proud on its very high scoring on the doing business ranking of the World Bank, where it features, I think, for at this point on place 9, which is extremely high for a country like Georgia. But as Lika already mentioned, over the past 10 years, a growing awareness has developed that a better balance must be found. And that expressed itself in the fact that if you look at the association agreement and the free trade agreement with the EU, then there are certain requirements that Georgia committed to in terms of harmonizing its legislation with a series of EU directives. So when we, the ILO, assisted the parliament and also cooperated with the ministry in reviewing and revising the labor code, we not only looked at ILO standards and ratified ILO conventions, but also these EU directives, and many of them relate to occupational safety and health. So they are not just reflected in the labor code, but also in the 2019 law on labor safety. So there's definitely a very strong link between Georgia's relationship with the EU and the trade agreement, the association agreement, and the changes in the regulatory framework. Thank you.
Thank you, Leo. Indeed, there is a certain influence that comes from it. Lika, you also would like, or anybody else? Lika, would you like to opinion on this or comment on this?
Can I say different? No, I fully agree. Of course, this agreement had very positive role. And the very fact that we signed association agreement with EU, was utmost importance, but it played crucial role, as well as the directives, for example, when it comes to attachment 21, and commitments taken by the country, would oblige us to make important steps in this respect as well. And it was crystal clear that Georgia had to do a lot more in this respect, and this was a very welcome development indeed.
Thank you, Lika. Indeed, the trade agreements have these trade and sustainable development chapters, which integrate elements of the responsible business conduct, respect to international labor standards, and so forth. It also relates to the input from Leo on the leveling playing field and the minimum norms and the minimum standards. Good. Nana, I hope your question was answered. Is there any other question or another point of view that on this topic? No. Okay, then I'll go to the final. Then I would like to first thank Lika for her input and her presentation on what is happening from the side of the Ministry of Labor in terms of advancing the decent work agenda to the international labor standards and the role of social dialogue, the central role of the social dialogue in this process, and on Leo on giving us the overall picture of the international labor standards system. Let me go then to the final slide of today, which is indicating the session of next week on occupational safety and health. We are expecting you on Thursday from 2 till 4 Georgian time on what will be an excellent session. And in the meanwhile, enjoy the rest of the day, and we will be in touch through email later today or tomorrow morning. Thank you.
Madhva.